Good evening, ladies and gents. Cyril here. This is week 8. We're dealing with express terms. And we've got two people, Michael and Jessica here. Any questions before we start at all?
No, I think I'm all good.
Okay, so let's start. Just let you know, when I went through law school quite some time ago, I found it all pretty complicated. So what I did is I put everything onto flowcharts, and you'll see here, probably can't read it, flowcharts. And to this day, I still do it in all my work. And on a single page, you can put a whole chapter, which is exactly what I've done. And at the end of the year, what you do, you summarize all the 12 weeks and you put them into one page. And that's what I did for every subject in law school. See, we had a bit of difficulty. We had to do examinations. And there was only one compulsory assignment in the whole course. Now it's probably swapped around the other way. So you don't have to do this. But the way my brain works is that I like to see it all on one page. And what I put at the top, I've written here, a person makes a statement. It can be one of three things: sales puff, a representation, or a term. Would you agree with that?
Yeah.
We've done sales puff already. Is that a term of the contract?
No.
No. So if you breach sales puff, what happens?
Well, not much.
Not much at all. And it could be like, Michael, Jessica, this is the best car in the whole world. And you know it's not. And it's garbage, you know. And a representation is just an opinion, something to think about. Again, it's not part of a contract. And generally speaking, there's no remedy for that. As was said in the lecture, when we in the second half of the course, contract B, there's a thing called estoppel, etc. But we'll leave that till later on. But just work on the assumption there's no remedy for that. And the third part is a term, and that's what people want to know. This is a capitalist society. We enter into a contract. I buy a hamburger, or I buy the hamburger shop, irrespective. I've agreed to this and you've agreed to that. And I'll refer you to my diagram, which I've shown you over a number of weeks now. You'll see there. That's your consideration. An arrow in each direction. And what is going in each direction, you need to be very careful. Today I've been working furiously on this negotiation. And we have to be very, very careful as to who's going to be offering what, etc. And it was in the back of my mind about this here. Okay, so as I said to you before, the express terms are broken into sales puff, representations, and terms. We're going to be focusing on terms, and that is your paragraph 2.1. And then we had two main branches underneath term. The first one are the types of terms, and then the incorporation of these terms. Incorporation means bringing the terms into the contract. And in the incorporation part, there's written terms and unwritten terms. But let's focus first on the types of terms. Now, we have three types of terms. Can someone give me those three types of terms?
Express, warranty, and intermediate terms.
Okay. So just slightly different. It's a condition at one end,
yep,
which goes to the heart and soul. In other words, it's the whole of what the contract's about.
Oh, yes, sorry.
Then you have a warranty.
Yeah.
That goes to it doesn't go to the heart and soul. And then you have something in between, which is called intermediate. Okay, so Michael, you're in Perth, aren't you?
Correct.
So I fly over to Perth to do a job. Go to the car lot and hire a car. The motor doesn't work. That's situation A. Situation B, the CD doesn't work. I want to play some music only for personal pleasure. Which is the condition and which is the warranty? Because both are breached.
The condition is the car not working.
Yep.
And the warranty would be the other one.
Right, exactly. And really, there's a lot written in your book, and it gets really complicated when it comes to intermediate terms. Don't get yourself all flustered over this. You should really just think about the conditions and the warranties. There is a tendency nowadays not to use those words. We use essential and non-essential terms. And there's a case called Kumpatu, which is about 10 years ago, High Court case with Aboriginal group of, I've just forgotten what it was. And the High Court spoke about essential and non-essential terms. So condition is basically or an essential term. It goes to the heart and soul of it, as does the motor in a car. Now, the CD not working is a breach. There's no question it's a breach. But it doesn't go to the heart and soul. I can still drive the car around, and it's still an annoyance, and there is a breach. Okay. And don't forget, the whole thing is based on the reasonable person test. What would the reasonable person consider it to be an essential term or non-essential term? Now, what happens if you have a breach of an essential term? What's your remedy there? Well, your remedy is that you can terminate the contract. And the reason being is, well, I don't need the car anymore. You know, you've substantially taken the benefit of the contract away. What do I need the car for anymore? I mean, how can I go from A to B when this thing doesn't work? And so the breach is of that. Now, the other one is a breach of a warranty. You can't terminate. And you've got to be really super, super careful if you want to terminate, but it's not a condition, not an essential term. And if you want to see an interesting case or series of cases, you've all heard of Wembley Stadium in London, the home of soccer. Well, an Australian company built that. It's called Multiplex.
Multiplex, yeah.
Now, Cleveland Bridge did the ironwork over it, or did part of it. Multiplex used very, very strong arm tactics, and not me just saying that. It's the judge himself said that. Used very strong arm tactics, and Cleveland Bridge thought there was a breach of a major clause. Okay, in other words, a condition, breach of a condition, breach of an essential term. And they terminated. And then Multiplex came back and said, you've terminated a warranty. And because you're not allowed to terminate, you've breached the contract and we want 50-odd million pounds from you. And there were 8 cases. And the judge said, I've never seen parties more intent on litigation in my life than these two. And they're at each other's throats. Now, basically what happened, the judge agreed with Multiplex that it was only a breach of a warranty, not entitling Cleveland Bridge to terminate. Cleveland Bridge could only ask for damages. Now, because Cleveland Bridge terminated, well, what I meant to say is that because the injured party in this case would be Multiplex. Because Multiplex was the injured party, it's already been terminated. It can ask for damages. It wanted a very substantial amount. However, there was a clause in the contract which stated that damages would be limited to £6 million. And you know enough about clauses and contracts now. The judge said, fine. They agreed to it. No gun in anyone's head. They agreed to it. And that was allowed. And so therefore, all that Multiplex got was £6 million. It wanted more, and we won't go through it here because it's beyond the scope of this court. There are also £22 million in legal fees. Can you believe that? £22 million. And the judge said that although Multiplex was the winner, because it brought the litigation and it really was very belligerent in the whole thing, it only got 20% of legal fees back rather than a great amount. It's really to show them, you know, you shouldn't be doing this.
Yeah.
So what I'm trying to say here is, first of all, you focus on essential and non-essential, which is basically your conditions and your warranties. Now, you'll sit there and think, well, when is he going to get to intermediate terms? Well, it's a case called Hong Kong Fur and Kawasaki case. It was about a ship. And this made it a little bit difficult for everyone. And basically, you can imagine there would be let's say a light at the back of the ship.
Yeah.
Now, if the bulb burst on that light, well, therefore, obviously, there's no light. It's a breach of contract. Ordinarily, would that be a conditional warranty?
Warranty.
Warranty. It's just like in my office here now that the bulb bursts. It's I can use something else. However, if that was the rear light, like we have in the back of a car, back of a train, back of a boat, a sort of light which just flashes or goes red or whatever, I suggest you that that's a condition. And that's the whole thing. This is brought into our law intermediate terms. And this is where you look at the consequences of what happened at the breach of the term. So I can say to you, probably the best way is to look at conditions and warranties. And if there is something which can swing both ways, it could be an intermediate term. If it's an intermediate term which has very serious consequences, like the light is the red light at the back, which signifies care must be taken so you don't run in the back of the vessel or whatever it is, that would be a condition. And if it's not, doesn't go to the heart of the contract, it's a warranty. So I wasn't going to look at much more than that, but to say is that just know your difference between conditions and warranties. Because if you want to get rid of someone, you have to go looking for a major breach. Now, Michael, let's assume that you're a big businessman and I'm dealing with you and you don't like the contract anymore. You want to get rid of me. You have to find that I've made a major breach. If there is a major breach, you can then terminate. Okay? All right. So unless there's anything else, I'll go to the next part. See, under the heading of term, there are two branches. Types of terms, like I've just gone through with you, conditions and warranties, and in between the intermediate terms. And these things we'll cover again when we come to our tutorial questions later on. Underneath the other branch is incorporation of the terms. How are we going to bring them into our written document or our unwritten document? So let's do written documents first. Now, when it comes to written documents, how do we incorporate these things in? Well, the first one was by signature. And I don't have to tell you, by putting your squiggly signature underneath something, you're bound. Now, either of you, can you tell me what happened in Lestrange and Graucob? Either of you know that case?
That's the cigarette. Well,
Yes.
that's the vending machine.
Yes.
Yes, and the machine wouldn't work correctly.
Mm-hmm.
So she sued him, or she stopped making payments because it didn't work anymore. And then they went to court, and then she lost. This is what they're saying, it's the unfair case.
Why? Did you cry? Were you upset?
Not me, but she.
Why did she lose?
Because she didn't read the contract.
There was an exclusion clause there.
Exclusion clause.
And whether you read a contract or not, it's irrelevant.
Yep, you should read it. Therefore, you've signed saying you've read it. Doesn't matter if you haven't. Yeah.
I remember a case, remember Crazy John? We used to have a guy called Crazy John about 10 years ago. And he's
phone guy, yeah.
Phone guy. He entered into a contract with Telstra. And then he said that he had a separate agreement with the Telstra marketing manager. When the marketing manager left and the new one came in, the new one looked at the contract and said, Crazy John, you're not following the contract. And he said, oh, we got a separate agreement. Well, that's pretty unusual. Anyway, so AJ Myers QC in the case where Telstra was suing him for $42 million said, Mr. Ilham, can you look at clause number 14? Can you read it out? Oh, it's an entire agreement clause. Everything lives in this document. And Mr. Ilham, can you have a look at the bottom of the contract? Tell me whose signature that is. Oh, that's my signature. But I didn't read the contract.
Yeah.
$42 million it cost him, okay? Had to pay that. There was a little bit of adjustments at the end, but in essence, it cost him $40 million. And he was dead 6 months later, so you can see that the stress got to him.
Yeah.
So the rule is, we've got 4 cases: Whitlock and Musgrave, Jones and Jones, Lestrange and Graukob, and Toll and Alpha Pharma. They all basically, particularly Lestrange and Graukob, they all say, read the contract, and if you put your signature to it, you're bound by it, irrespective of whether you've read it or not. Okay. And Toll and Alpha basically say the same thing. Now, subsequent to this, we've got to keep up with the modern times. We've got PIN numbers, and we've got all sorts of fancy ways to sign a contract. And the Electronic Transactions Act of Queensland, Section 14, allows these to be treated as signatures. Okay. So there we are. Now, we can also incorporate by reference, as we will see in our tutorial question. Look, the terms and conditions will be found at www such and such, or the terms and conditions are those in your letter of the 15th of December 2017. So you can incorporate by that. I don't think there's an issue there. Any problems with that? The next one is incorporation by notice, but you have to give sufficient notice. Okay, and it needs to be an actual notice or a constructive notice. Actual notice is where, look, Jessica, there is something you need to be aware of. I'm pointing it out to you. Or constructive notice, it's there and you should have seen it. Jessica, are you able to tell me about Balmain and Robertson? Balmain, New Ferry and Robertson?
No, I can't. Sorry.
There are basically a couple of really key cases in the law. In contracts, this is one of the key cases, and later on we'll have in torts, which is negligence, we'll have the snail in the bottle. This is quite an amusing case. Mr. Robertson was a barrister. A barrister is a lawyer who fights cases in court. This is my recollection, okay? He had a practice in the city. He lived in Balmain. Now, the harbour bridge hadn't been built in those days, but had it been built, he would sail, he would catch the ferry underneath the harbour bridge to Balmain. Quarter of an hour, 20 minutes, whatever. Now, because it was difficult for people to pay at these different harbour destinations, it was just easier. You pay when you get onto the wharf, and you pay when you come off. And above the turnstile, where you push your body, it goes click, 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 and you go in one direction. Of course, you can put a coin in. Above that, there were the rules that to get onto the wharf, 1 penny, and to get off the wharf, 1 penny, irrespective of whether you've travelled or not. Okay, so he and a friend were going to go back to his place. And they got on, in my recollection, he missed the ferry, and they decided to stay in the city.
Correct.
Turned around, and he wanted to leave. And the turnstile operator said, sorry, he can't let you go because the rules state whether you've done it or not. And to impress his girlfriend, he said, oh, look, I'm a lawyer. I know better than you. You have not given consideration, and therefore I'm not bound by this, and I'm going to go through it. And there was a big argument. And he paid the penny, which is like about $3.50 now. I'm not quite sure how much it costs to get there, but it's about like that. $3.50 to get to, he paid the penny to get her out, and he asked her to go and get the police. Police came back, found him in a headlock on the ground. And he sued the Balmain New Ferry Company. He sued them for assault and battery because you can't touch another person's body without their consent. False imprisonment and assault and battery. And in the Supreme Court, he won the case. Now, what happened? A lot of people walking off the wharf. So the ferry company had to appeal. They lost the case, went to the High Court of Australia. High Court of Australia, they said, no. This is a contract case. These were the terms and conditions. Now, he was aware of the terms and conditions because, number one, he's a lawyer. You're supposed to understand these things and spot these things. Number two, he's been going there each way, year in, year out. Okay, now in plain English, just above the turnstile. And remember, you must see the terms and conditions prior to the contract creation, because afterwards it's stupid. It's already been created. And High Court of Australia gave it to the ferry company. No, Mr. Robertson said, no, I don't agree with this. And he appealed. And in those days, you can appeal to the Privy Council, which is in London. The Law Lords fully agreed with the Australian High Court, and Mr. Robertson was known for the rest of his life as the man who went to the Privy Council for a penny. I did a mental calculation a while back. I reckon he paid $1 million. So what's the price from Circular Quay to Balmain? I don't know, $3.50, $4. And that cost you $1 million. So you just got to be a little bit careful with these things. So that's the case of Balmain and Robertson. And the other case was Oceanic Sunline and Fay. And my recollection of that is that the people had bought their tickets. They went on a boat, and they were given more terms and conditions. He was injured, and he sued, and the shipping company purported to bring these terms and conditions in, those which had arrived after entering into the contract. Yeah. Irrespective of whether they read the case or not, can those terms and conditions be incorporated into the contract?
No, generally.
No. Why not? I agree with you. Why not?
Well, you've already signed the contract, or you've already agreed to the contract to bring out later terms.
I have this. I do a bit of travelling in my work. I have this every single time I go. I'll book a hotel on the internet, or I will ring up and say, oh, Jessica, look, would you mind one room? How much? Yeah, that's fine. Click the card, please. Blah, blah, blah. I get there, and they say, oh, Dr. Django, pleased to meet you here. Look, could you please sign this form, please? And my standard response is, oh, why do I need to sign this form? Oh, sir, in case you leave your toothbrush here, we need to have an address to send your toothbrush. Oh, okay, show me the form. And there it is. We are not responsible. This, and this. What are they trying to do? Introduce terms into a contract. Okay. It'd be interesting if I signed those clauses, the terms with the doc with that, whether I've given consideration at all. What I always do is I put a line straight through it, I put an X, a box around it, and I initial it, and so it's crossed out. Of course, I have to pay the bill. Of course, they don't want you to smoke in the room, and of course, I can't have more than 200 people in a party in my room, etc. You know what I'm saying? But the real guts of it, where they take they take no responsibility. That's what I cross out. See, I don't want to have to argue in court that they've abrogated their liability for doing anything, and it's no longer a contract. There's no consideration. That's a major court case. It's made it just easier. Put a box around it, put a cross through it, and initial it. No one has ever said anything to me. So what they're trying to do, they're trying to bring a condition into a contract after the contract's been struck, and it happens every day of the week. You'll have, let's say, on a building site, and a tradie will come and say, look, I know I quoted 10 grand plus GST, but it's been twice the amount of work. I want 20 grand now, or we want to do this. It happens every day of the week, and you're just going to be firm. It's a commercial decision whether you want to pay them more, but legally you don't. Okay? So that's the incorporation by notice. The other one is unusual terms. Now, if there's something super duper important, you can't bury it in a document. You should bring it forward, because the whole issue of fairness, which is the reverse of unconscionability, is that you need to be made aware of a clause. If you don't make me aware of it, and like I said to you before, actual or constructive knowledge of this awareness, if I'm not aware of it, well, therefore, why should I be subject to this term in the contract? So just remember this for the rest of your days. If you want to put something in, and it's really, really important, it's really, you don't bury it somewhere, you may wish to bring it out. And a better way of looking at it is, I was looking at the case before of Thornton and Shoe Lane parking. Now, this was in London. A guy went to a car park and he parked his cars, all the terms and conditions there. And he went out and he came back and he was injured. And he sued the car park. And the car park said, oh, no, buried in there, there's this exclusion. We are not liable for serious injury or death. Lord Denning, quite a renowned judge, said, well, hang on, this is not right. It's unconscionable to that he is bound by these terms when it was hard for him to know about it in the first place. The more serious the injury or death or something like that, the more it should be in bigger letters and in red. Okay, so that's what unusual terms is all about. Okay, so that's about written terms. Then we had unwritten terms, and we're talking about 4 things here: the parole evidence rule and its exceptions, the general considerations, in other words, is it a representation or a term, collateral contracts, and incorporation by custom. Okay, so can someone tell me what the parole evidence rule is?
Basically, anything outside the contract terms and conditions that was stated is not admissible in court.
Yeah, outside the written. One word you missed. Outside the written document.
Yes. Okay, outside the written contract, yeah. Yeah,
and it makes a lot of sense. You and I go into a contract and we've thought long and hard about it, and then later on one of us comes back and says, we said this, this and this, Yeah. An independent third party would say, okay, that's not. There are a couple of exceptions to it. The first one is a collateral contract. Now, a collateral contract is a complicated area. And there was a case called De La Salle and Guildford. And this man was a tenant. In the last house, he was flooded out. In other words, the gutters didn't work properly and he was totally flooded out. In this house, he went to the landlord. So, Michael, you're the landlord. And I say to you, Michael, are the drains in good order? And he said, yes. Michael says, yes. So based on your representation to me, I then enter into the main contract.
Yeah.
And then what happened? The drains didn't work, and therefore I sue you for breach of a collateral contract. Now, collateral contracts are an additional contract on the side, hence there's a reason why there should be an exception to the parole evidence rule. And I think we had, there are other cases on that, but just keep it very simple like that. Now, another one is evidence of a variation. So Jessica and I are in the contract, and I'm supposed to provide 100 of whatever, and we've now decided 120. Now, we don't amend the contract. That's a verbal amendment that we've made. That can be used. Of course, there's a problem of proof involved. And the last one is a rectification, is that, as we saw in the notes, the consideration was supposed to be 100,000. I'm buying your vote for 100,000 plus, if there is GST, let's say 100,000, and I accidentally type $1 million. Of course, you want $1 million, and I go to the court and say, look, it was an error. It was always this. And objectively, you look at it again, it was clearly an error. So that's the parole evidence rule and exception. Sorry?
Unjust enrichment.
Yeah, because it's an unjust enrichment. Because, see, what happens, just give you a bit of a quick lesson in contract law. The rules of contract law became very bogged down long time ago, in the 1500s, 1600s. And there was a lot of shenanigans going on where people would use contracts to become unjustly enriched, as was the case the one I just gave you. You go to the court says, look, we know it's $100,000 boat, but he says to me, you have to pay the $1 million because we are dealing with the law of contract. Now, the law of contract wouldn't allow, also it required me to pay the $1 million. So that's unjust. And so a new branch of law called equity stepped in and assisted where it was unconscionable, it was unfair, unjust. Indeed, using the word equity there to assist. And unjust enrichment would come in and say, no, it would have to be. It would have to be just 100,000. Now, in the hierarchy, contracts are here, equity sits on top, and legislation sits on top of that. So that's the first of the three issues I wanted to talk to you about, the parole evidence rule. The second one, general considerations, is it a representation or a term? And really, a representation is an opinion. Well, I reckon, I estimate, and you remember in the Savage case of Blakely.
Sorry, hang on.
Was that you talking to me? In the Savage case and Blakeney, Savage were the people who sold the motor to the boat, said, we estimate, we estimate the speed, I think it was 15 miles per hour, and it wasn't. And Blakeney took them to the High Court of Australia. And indeed, what had happened is the High Court said that it should be, it was a representation, not a term. So that was the case of Savage and Blakeney, held to be a representation, not a term, because of the vagueness of the words, or actually the actual word, I think, was estimated. All right. Now, the next one is the expertise of the parties. So I'm looking for a car. Michael, you're the salesman, and you say, oh man, this is the best car in the world. It is no better cars in the whole world. I think that's sales puff, or it could be, if you make an estimation, I think it's done this. It could be representation. Now, if Jessica, you go away and Jessica comes out, she's the mechanic, she's talking to me, wipes the grease off her hands and said, sir, look, I know this car, I know the history of it, and it's done 50,000 Ks, and I would confidently say to you, it can do another 150,000 with only minor repair work. I'd suggest to you that what she has just said becomes a term. And what is a term? The term is this here. They become the obligations. What Michael said as a sales puff or a representation doesn't end up here because it's not a promise. It's something in the background. But what Jessica said does end up here, and if it's a breach. Now, preferably what you do is you reduce it into writing so there's no dispute later on. And that's the difference between hang on, we've got some more. And it's the timing of them too. So if there's a long distance between when you give me some information and I've thought about it for a couple of days, well, it's probably more like a representation. And these things are not conclusive, but they all begin to add up. There's a case of Vanden Essert and Chappell. Michael is the vendor, and I'm the purchaser. And I say, Michael, look, a Perth case, as it was, Western Australian case. I say to Michael, any white ants in the house? I'm just about to sign. I've got the pen in my hand. And I'm just about to sign. I think, oh, Jesus, I don't know. Michael, are there any white ants in the house? And Michael says, I assure you, there are no white ants in the house. Yeah. It was not put into the contract. Had it been put in the contract, it would never got to court. Well, there are white ants in the house. The buyer said, but you told me there were white ants. Well, it's not the contract. Went to the court, and the court said it was a term of the contract, an oral term of the contract. Okay? Because the proximity of you gave me the assurance, and based on that assurance, very, very shortly afterwards, I signed the contract. Okay? It was meant to be here, in terms of the contract. Okay. The timing, we just said that one. Whether and if indeed it was reduced to writing later on, that's pretty obvious. That if we spoke about 4 things and only 3 of them ended up in writing, I think it's pretty obvious that they're the ones we want to deal with. Okay? Now, once again, these things aren't conclusive because you can have arguments around them, but they're pretty strong. And the other one, which wasn't in the book but was in the lecture, Anthony Maronak was talking about emphatic. If I'm really emphatic, look, man, I'm just telling you, it is, I just guarantee it's 15 miles per hour is the speed of this boat. I guarantee, I just tell you, that is far different from, look, man, I estimated at 15. So these are all the factors that you put together. Now, a couple other things. Collateral contracts, we've spoken about that before. There was a case of Wells and Buckland. And I think Wells and Buckland, from memory, was that case with the nursery. The nursery went to Jessica. And Jessica is the supplier of the soil. She sells the soil to Michael. I say to Jessica, Jessica, is this soil suitable for this type of plant? Because this is all the plants I deal with, the only plant I deal with, and that's the sort of soil I need. Jessica says, fine. Based on that, I then go to Michael and I enter into a contract. Now, Michael wouldn't have a clue about the quality of the soil because that's not his business. His business is just supply to it. And therefore, I can have a go at Jessica because there was a collateral contract. But when you read the case of Hoyts and Spencer, the collateral contract cannot go contrary to the agreement, and that's Hoyts and Spencer. So have a look at that. And the last thing I want to have a look at is incorporation by custom. There is a possibility that when we enter into verbal contracts, there are customs which will automatically bring in terms, but we were given 4 different things to consider that should be there. The existence of a custom or usage that will justify the implication of a term into a contract is a question of fact. There must be evidence that the customer relied on is so well known and acquiesced that in everyone making the contract in the situation can reasonably be presumed to have imported the term. A term will not be implied into a contract on the basis of custom where it's contrary to the express terms. And a person may be bound by a custom, notwithstanding that he or she had no knowledge of it. Okay, that's something we don't come across that much nowadays because commercial prudence is that what we do is we normally write terms and conditions in. There is a possibility you can bring them there. So I'm just looking at my notes here. That was the last thing I was really going to talk to you about, and that's a case of Constan Industries in Norwich. Okay, so just in summary, someone makes a statement. It can be a sales puff, which we did a few weeks ago. It can be a representation or a term. Now, a representation is where people are negotiating. Lots of things are said in negotiations. I can say to Michael now 100 and later on say 50 or 150. These discussions all go. What's really important for the parties is what actually ends up, what I have to do and what you have to do. They're the obligations. And those obligations are your consideration, are your agreement. And once again, we discussed if it's a term, is it an essential term or not an essential term? In other words, is it a condition or a warranty? And then it might be an intermediate term. How do we incorporate it? Well, we can look at written terms. Basically, we incorporate by signature or modern versions of signature. We have by reference, refer someone to another document, by a notice, or by giving them notice, they walk past a turnstile and sit, and if it's really, really important, well, you tell people about it and make big red signs. The other part was unwritten terms. So these are oral terms. You have the parole evidence rule where basically if it's in writing, you can't do much about that with an oral term, with the exception of one of the 3 exceptions, which is collateral contracts, evidence of changes, and rectification. And then we have whether it's a term or representation, and we look at the words used, the expertise, the timing, where it was later reduced to writing, and how empathetic a person was. We also spoke about collateral contracts and the Hoyts and Spencer thing you have to keep in mind, and then there's incorporation by custom. Okay, so that's the theory. We go. Let's now look at that from the problems. We've got two problems here. Just put my notes here. Yeah. Now, the whole purpose of this first question, being question 10 or problem 10, is that you need to know the difference between a condition and a warranty. And I think it's, in essence, we've done that already. But the question for us is the distinction between a condition and warranty in intermediate terms useful? Could either of you give me a hand on that? How would you answer that? Is it a useful distinction?
Well, intermediate terms are very broad, so it can be very important to not important at all. So
yeah, my answer to that is yes, comma, sort of.
Yeah.
Does it help you? What I'm trying to say is I'm not a big fan of intermediate terms. In my opinion, it's better to have a condition and a warranty, and we stick to those, and have a look at whether they fit one or the other. See, the important thing is, I'm entering into a contract. I want to know what happens if someone's going to breach it. Okay? So if I provide you with the car and the CD is not working, I know you can't do much about it. You can't get out of the contract. And if you ask for damages, what's your damage? Nothing. But I do know if I don't give you a motor which works, I'm in deep trouble. Okay. So the important thing for you to remember is the distinction between conditions and warranties. Intermediate terms don't really hold anything. It's just there was a case 30, 40 years ago which spoke about it. If you feel there is a minor term which can have a major catastrophic event effect on the contract, well, therefore that will be treated like a condition. And the example I gave you, in the back of a ship, here's the ship. On the back of the ship, there's a light, and that light is super important. And a $1 globe bursts, that ship is unseaworthy. You see, and that becomes a condition. But ordinarily it wouldn't. So you got to just keep in mind the two main ones: conditions and warranties, and the one in between. And if it doesn't, if it's not essential, well, therefore it's treated like a condition. If it goes to the heart and soul of the contract, an essential contract, well, therefore it would be treated as a condition. So the second question, second part of that question, would it be better to look at the consequences of breach rather than the term to determine the appropriate remedy? Well, that's just what I just mentioned to you. It's really important. So, Jessica, you're running a business, and you feel that it's going to cost you too much to do this contract. You agreed upon a really high price, and now prices everywhere are dropping. And you think, oh, it's just cheaper just to breach the contract and pay the damages. Well, I think it's important to know whether it's going to be a condition or a warranty. In my previous life as an accountant, I used to do a lot of work for the court, where I can't tell you how many times a lawyer would ring me up, go in their office, and they'd say to me, look, our company our client's company have decided it's cheaper to breach the contract, pay the damages, then to go ahead. And if I can work out the damages, and then they'll do an estimation. So they pay me a couple of grand to do a report. I do the report, and then they look at it. Let's say I work out there's going to be $1 million damages. Now, if they can make $2 million elsewhere using the same resources, well, they'll just breach the contract and fight really hard and maybe pay $750,000 to $1 million and make money elsewhere. So that's how commerce works. There are ethical issues there. Let's leave that aside because we're talking about the law here. Let me just see what notes I've got here. Yeah, I've got this other one here, just a note here. Let's say a ship doesn't have enough lifeboats on board. Now, if the ship has just left port A, and going to go to port B, and it's a cruise ship, that's clearly a breach of a condition. But if it's 5 minutes from berthing, in other words, arriving at the other end, and there's seen to be a breach there, well, it's only a breach of a warranty because what's the problem there? Okay? Yeah. So what I propose to do now is to go to the next question. That's with our man, Mr. Abda. Remember the old thing we did last week? We need to look at parties and we need to look at facts. Well, we've got Abda is the passenger. The captain might be a party here, and government. Government is the authority. So at the very least, we've got Abda and the authority, Transport Authority in Brisbane. So Abda's on holidays, wants to use one of the CityCat ferries. He's unfamiliar with the ferry system. He's waiting for the ferry. He sees a sign which says, for terms and conditions, go to the website. He tries to search him. He can't get a signal. Second paragraph. He boards the ferry and pays for the ticket on board. On the back of the ticket is fine print. As a condition of boarding and remaining on board, you must abide by all reasonable directions from the captain and crew. For full terms and conditions, see the website. Tries to see the terms and conditions. Again, no signal. Third paragraph. He sees a sign on the cabin wall which says, slippery when wet, use at own risk. Hold onto part of boat with one hand at all times. Fourth paragraph. He's taking photos. He loses grip of the camera and falls overboard. Captain refuses to turn back, and he comes to ask for advice. Okay? All right. So, the first question, is there a contract between him and the ferry authority? What do you reckon, Jessica? Is there a contract?
I'd say no, but I'd say there was a contract between the captain and his employer.
Okay. So you reckon there's a contract between the captain and the and Abda?
Or the company.
Company, yeah. So that's the authority. Let's leave the captain out for the time being. So we'll just say between the government authority, the transport authority, and Abda, there's a contract.
Yeah.
Okay. Because there, how do we know there's a contract?
Ticket.
Anyone, Michael, or both of you?
There's a ticket.
There's a ticket. Okay. So there's an offer and acceptance there. Now this is the difficult part. When was the contract made?
Well, as soon as you purchase the ticket.
Purchase ticket. There we are. So it's not when he walked on. It's the ticket. Now, if he snuck on and didn't pay, and he was injured, there is no contract.
Yeah.
So he can't sue for breach of contract. Now, you haven't studied this yet, but have you heard the word negligence before?
Yes.
Negligence is a duty of care. It's like when a doctor cuts the wrong lung out or something like that. I had a eye surgeon down the road. He came to me one Sunday. I thought, what's he doing here? Because he never talks to me because I'm not a surgeon. And he wanted to come in, so I made him a coffee and I said, what can I do for you? He said he operated the wrong eye. He asked me, did I think he was in trouble? I said, you're in deep trouble, man. Go to your insurance company the next day. You know,
Yeah.
it's just negligence. You know,
No.
I as a patient, not only is it negligence, it's a breach of contract, isn't it? Negligence, you'll learn further down the track. The reason why we have negligence is when there is no contract, you can't leave people uncompensated. Okay, so when I have purchased a car, I'm the boss, and Michael, you're my employee, you use the car and you're injured. There is no contract between you and the retailer of the car.
Yeah.
So you go straight through and you sue in negligence. Let's leave all that for another time, but we're here. Now, so I lost the train of my thought now. A contract between, so there is a contract
At the ticket.
when the ticket was made. Question B, does the text on the ferry stop sign form part of the contract?
Well, I guess it depends on the sign. I mean, if it's saying watch your step, but generally no, because it's post-purchase.
Yeah. Okay. So let's get our signs right first. When he was sitting in St. Lucia, sitting on the seat, waiting for the ferry to turn up, he saw a sign. If that's the one we're talking about, that's pre-purchase.
Yeah.
Okay. As long as we get our facts right, it's pre-purchase. That could form part of it. But remember, he was not able to get through. Now, the question for you guys is there a contract? Also, was he bound by the terms and conditions? Because remember, he was not able to search them. This is a really difficult question.
He wasn't able to search them or didn't have time to read them?
Well, remember, on the sign it says, go to www, and he tried to go there, but he couldn't get the signal on his phone.
Well, he still went on the ferry, so he's accepted it by
he still accepted the contract.
Yeah, good on you. And I had to think long and hard of this, and I spoke to Anthony, and the answer to this is, and it does sound a bit unfair, but no one forced him to go on the boat. And if he was really concerned about the terms and conditions, he could have gone somewhere else to get a signal and to look it up. So he would be bound by the terms and conditions. However, if there are any really extraordinarily serious consequences above and beyond what you'd ordinarily expect, they probably would not take effect because they were not made aware. He was not made aware of them. Okay. So where are we here? And now the website. That's right. So the sign itself, yes, and the website. Now the next one was whether the text on the back of a ticket would form part of the contract. And on the back of the ticket, it said something to the effect of, where are we here?
Paragraph 2.
Paragraph 2. On the back of the ticket in fine print, as a condition of boarding and remaining on board, you must abide by all reasonable directions from the captain and crew. And for the terms and conditions, see the website. Okay? So I'd say to you that potentially he may not be bound by what's written on the back of the ticket because he didn't see them, because the contract was formed beforehand.
Okay.
And that was an actual case. That was in Thornton and Shoe Lane Parking, the one I gave you before. Lord Denning said, I think it was that case, or another case that I was reading before. I sometimes get confused, but there's another one, a Sydney case of Sydney City Council and West. One of those two cases, the judge said, I think it was Sydney City Council and West. In the minority, one of the three judges said that So I just losing my train of thought here.
What was it? Sydney City?
No, actually, I think about it now. It was it was the other case of Thornton and Shoe Lane parking, where Lord Denning said that the ticket had been issued after the contract had been made. Therefore, it's not correct to be bound by terms and conditions when you weren't aware of them. And I think that's what you've got to remember. In examinations and in the real world, it happens all the time. I like the example I gave before, the builder. You've struck a deal and he comes back and he wants to introduce more terms. But you've got to be really careful because notice is required. Our system of contracts requires for a person to be bound by a clause, they have to be given notice. And if they haven't got notice, the clause does not apply. Go on.
Say he's bought the ticket and then he's given those extra terms after he gets, or say once he gets to the ferry, but he hasn't gotten on yet. If he gets them and then he jumps on, isn't that him accepting those terms?
So it's at the time of purchase, you have to look at what notice he was given. Now, there is actual notice, and constructive notice could be like Mr. Robertson. Mr. Robertson every day had gone onto the wharf, on and off the wharf. And because he did that for so many years, he'd be expected to have known what was on the what the terms and conditions were. So maybe have I answered your question? If not, ask it.
Yeah.
Once again, our system sees it's unconscionable to be it's unconscionable to enforce terms which a person was not aware of. And so to make him aware, you really have to go out of your way to expressly make it aware or by constructively. Now, constructively means that if I give you a document and I tell you these are things you've got to watch out for and you don't read it, it's not my fault. The fact is that I made you aware of it. Okay. So in reverse, if you have a question and someone says to you, this and this happened, and there's a document here, were you aware of it or not? Give an example. A very good friend of mine got married, went to the church, afterwards went to a hotel for drinks. It's in the city of Melbourne. Busy Saturday afternoon, something like that. Couldn't find a parking spot, a bit late, caught in traffic. So what we did is gave my keys to the valet, and the valet gave me a piece of paper, a small piece of paper, size of a mobile phone. Name of the hotel, terms and conditions. Underneath, he gave me a pen and said, "Sir, please sign here." Now, if one of those conditions was that they're not responsible and something happened, it's very, very hard for me to say I didn't know about it. Because what does Lestrange and Graucob say? Whether you read the contract or not, you put your signature to it. That's a very, very critical case. And as the driver took my key and he was walking away, I noticed his nameplate. It was Ferris Bueller. If you've seen Ferris Bueller's Day Off, it's a funny film. So I joke when I say that. So always make it known, because then you don't have as it's more likely to be a contract. Now the other thing is that you've got to be careful if you're this authority, this transport authority, and you exclude liability for this, and this. Well, remember a couple of weeks ago we did consideration. Well, consideration could be seen to be illusory. In other words, what are you getting at? They have the option of doing nothing. And so there is no contract. Okay?
Yeah.
And so they might have an exclusion there, and that's if you come to the conclusion there is no contract there, well, therefore the exclusion won't work, and then you can have a go at it. So, look, it was not an easy night, and that's why I wanted to show you at the very beginning the flow chart, because I think we had 20 cases here. The record was 4 or 5 weeks ago when we had 28 cases. I think that was offer acceptance, which is agreement. And we had about between 10 and 15. Now you have 10 weeks, let's say in round figures, 10 weeks at 15, there's 150 cases. Now, I know it's a lot. So you should be able to very briefly know which each does, and particularly the more important ones, and just be able to navigate around, because if someone talks about express term, you should straight away see, yes, we have a distinction between sales puff, representations and terms. What's the difference between the three? Sales puff is relatively straightforward in comparison to the other two. There could be a fine line between. Just know how the different types of terms there and how you incorporate the written ones and the non-written ones, okay? And just get a bit of feel how it goes. And when you're walking around, and as I say this to you every week, you watch a movie, you read the newspaper, you're just walking around, see how this happens in the real world. What happens in the real world? When you're at work, or if you're not working, when you go to a hotel, as I said to you, you have to sign a document, or when you go to the... let's have a quick chat about the dry cleaners, okay? Now, today Melbourne was 37 degrees, hot, smelly, sticky. I take my shirt or whatever it is to the dry cleaner, okay? And they gave me a piece of paper, and I go back, and my lovely shirt, which I spent quite some money buying, let's say I don't know, a famous brand shirt, cost me a couple of $100, completely ruined. And they say, oh mate, on the back of the ticket there was a disclaimer. Would that disclaimer be effective?
No.
Why not? I agree with you. Why not?
Yeah, because it's after the contract.
Yeah. It was not made known to me.
Yeah.
Expressly or another way, by constructive notice. It wasn't done that way. Yeah. And there was an actual case on that in Victoria 20, 30 years ago. There's a couple of cases on that. And I'm getting my cases all mixed up. A guy took his wife's wedding dress to have it done, and they came back with a big huge black stain on it. It was totally useless then. And the guy said, well, on the back of the ticket. And the customer said, well, I didn't know there was anything on the back. You never told me. There should be a sign on top. And that's why the hotel, in my opinion, were very clever. They had, as I said to you, a piece of paper the size of a mobile phone, the hotel's name, address, half a dozen terms and conditions, underneath where you sign and you date it, and then obviously put the rego on it and things like that. Very, very hard for me to get out of that. And Lestrange and Graucob would be the case if I said I hadn't read it, Okay, I wasn't going to do much more than that. It gives you a bit of a feel of the thing. Try to use some of these, experiment with them. Next time you go on a ferry or a bus or something like that, have a look. Would these terms be incorporated? Okay. You indeed take your laundry down, you take your car down, and you have to sign something. Okay. There was a case, Holly and Ramble Motors, many years ago. I remember a guy had taken his car down to be repaired, and overnight the place burnt down, and he lost his car. And there was on the back of the form, which he signed, the terms and conditions were on the back. And he said he hadn't seen it, and the judge had looked and said he'd been to Rambler Motors, I think 3 times in 5 years. And the judge said that was not enough number of times to have been there to know there was terms and conditions on the back. But Mr. Robertson from the Balmain Ferry Company case had been going through that turnstile every day for years, backwards and forwards, and the sign was just above the door. Yeah. Okay. Now, just while we're talking about these signs and things like that, it would be definitely unconscionable if a blind person came through and you tried to enforce that sort of thing. That goes contrary to good conscience, and equity would step in and assist. And nowadays we also have a statutory unconscionability in the Australian consumer law, which we'll see later on.
Yeah.
Okay. So I wasn't going to do anything more. Michael, any questions?
I'm good, thanks.
That's good. Jessica, any questions? Okay, we will see you next week. All the best to you, okay? Catch you.
Appreciate
See you
it.
later. Bye-bye.